G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers. Thank you for watching and listening to the Australian Family and Fertility Law podcast. If you're watching this on YouTube, please subscribe. We love subscribers. It gives us an idea of who's watching and what you actually like, and give us feedback of what you think of these videos. But this video is about a recent court case, and it involves a brave couple and an intrepid lawyer. For too long, Western Australia has discriminated against same-sex couples, male couples, and single men, as well as other people on the LGBTQIA+ spectrum who aren't lesbian couples, from undertaking surrogacy. Because the Surrogacy Act 2008 in Western Australia specifically says that you can only access surrogacy there if you're a single woman or an eligible couple. So hence, lesbian couples can access surrogacy, but otherwise you've got to be a heterosexual couple. This particular couple, Mr and Mr Dunn, weren't very happy about that, and they decided to challenge things. Now, let's put some context to this. The Surrogacy Act in 2008 was one of the first pieces of surrogacy legislation in Australia. It was the second after the ACT, I should say. And it was designed to allow single women to undertake surrogacy there, because it was thought that that would therefore survive a challenge under the Sex Discrimination Act. But there wasn't any allowance for same-sex couples or single men, and this then became a topic of criticism. I certainly criticised it when there was a statutory review back in 2014, and a colleague of mine from Western Australia, Barrister Rachel Oakley, had been criticising it even before then. And at every available opportunity since then, I've certainly been critical of Western Australia for not removing this discrimination. In 2017, I wrote to Roger Cook, who was the then incoming Health Minister, and I said, look, the changes under the Gillard government to the Sex Discrimination Act, which then protect LGBTQIA+ people, had a protective period in Western Australia, which means that this discrimination could be allowed in Western Australia, finished in August 2017. At that point, when I wrote to in May 2017, you're going to be in trouble. And really what Western Australia has to do is either to legislate, which would be the preferable course to remove discrimination, or to wait the inevitable challenge, which I said Western Australia would lose. The response of Minister Cook was to get a review done, and the review recommended, amongst other things, lots of other things it recommended about regulation of IVF in WA and surrogacy. But the number one priority was to remove discrimination. And in fairness to Roger Cook, a bill was put before the WA Parliament fairly quickly, and it got stymied in the upper house. The government did not have the numbers. Once bitten, twice shy. It took a lot longer for the government to then fix the problem. And it was only until the 18th of December last year that the Assisted Reproductive Technology and Surrogacy Act was enacted in Western Australia, which finally removed the discrimination. But that act hasn't started. The government has indicated that that act is likely to start in mid next year. Now, it may be longer than that. But what if you're a couple, you're a gay couple living in WA, and you don't want to wait? And why should you have to wait? Well, that's what the Dunns thought, and Mr and Mr Dunn, and they thought, we're not prepared to wait. And they brought a challenge to the Surrogacy Act as to this provision, and they were successful. And my good friend and colleague Rachel Oakley has been at the centre of that, and enlisted other lawyers to help, and made sure that this challenge was brought, and it was successful. All credit to all of those who are involved. Rachel got me to do a little bit of help on the side as to some issues about parentage, but I certainly can't claim credit for the thrust of it. She was really the hero, and the Dunns are the heroes. That decision was handed down in May, and 2 judges to 1 upheld the challenge. So the Dunns were able to proceed and seek approval from the Reproductive Technology Council and then be able to proceed with their surrogacy journey. They had previously been told that they were approved in every respect, except they were not accessible because of who they were, not as to their other qualities. And the time for seeking leave to appeal, special leave to appeal to the High Court, has expired, so the judgment stands. It's no surprise to me that the judgment came about, but there was an enormous amount of effort to get to that point. And it reminds me that of the old statement I've used a number of times, and I've experienced this in my own life. Test cases are very interesting, except when they're your own. For those of us on the outside looking in, it's great that this outcome has occurred. It's certainly, I predicted it would occur all those years ago, and finally it happened. But for those who have incurred the cost on the way through, both financial and emotional, all credit to you for having done that. Thank you. I'm Stephen Page from Page Provan Family and Fertility Lawyers. You're listening to the Australian Family and Fertility Law podcast. If you're watching this on YouTube, don't forget to subscribe. Thank you.